Well, let me begin by thanking the organizers for giving me chance to share my perspectives and thoughts. And uh, we're starting fashionably late. I shall promise to be short and sweet, but to just convey the following points. Just to start off with discussing that international law, at least from a preliminary perspective, and in terms of how Lord Bingham had perceptively put it when he said that times have changed to an extent which is almost unimaginable even 30 years ago. National courts in this matter and other countries have called to consider and resolve issues turning on the correction, understanding and application of international law, not on occasional basis, now and then, but routinely and often in cases of utmost importance. End quote. For that sense, in practice, lawyers in municipal courts regularly engage with international law in some form or the other, and here are a few examples where this is discussed and also highlighted. Courts frequently turn to these multilateral treaties whenever they rely upon to protect the individual liberties and also in some true matters involving rights to intellectual property. Courts, therefore, are called upon to adjudicate on these matters. Principles of public international law, such as territoriality, sovereignty, interact with the principles of private international law, whereas in the domestic courts and in, for example, such as freezing orders or for controlling the actions of defendants in foreign countries. Interactions with other instruments of law are also of utmost importance. Therefore, for the municipal courts, especially in this globalized era, especially in a country like India, the importance is of utmost value and significance. Therefore, to discuss this treatment of Indian courts of public international law, I shall simply refer to this as international law, and this court traces the history of the Indian Supreme Court with international law and the principles that are laid down in them. It will also analyze the relationship between international and municipal law, but also the acceptance of the dualist theory that shifts from the doctrine of transformation to a doctrine of incorporation. Finally, this chapter will also discuss the future of international law in municipal courts such as India. Therefore, the story really begins with the discussion which takes place on accounts of independence, at least for India, which goes as far as back as to 1858, where the British direct control began. Territoriality and also the directly governed principalities of India are of value and also discussion, which require further credence and study in such principles, or as this paper is highlighting. This arrangement of the princely states came together to be executed over decades between themselves and the East India Company, which latter cost the crown. Coming forward to the 20th century, only about 52% of the Indian territory was under the direct British control, and the remainder lay with the 560 princely states. States, although since then have been governed by the principle of sovereignty. If India was to be formed by a single independent nation, the sovereignty of the princely states would have to be returned to them, and subsequently each of them would have to come together to form a single nation, the Union of India. And that is something that happened on the 15th day of August in 1947 in the lapse of paramountcy. Sovereignty was returned to the princely states on that fortunate day. Most states signed the instrument of secession, ceding to law-making powers on issues of utmost importance to the country. However, by the 26th day of January 1950, India's constitution came into force, and most princely states had transferred their sovereignty in the favor of one single dominion, i.e., India. First interactions of the newly formed Supreme Court with international law concerned with the defects of sovereignty that had occurred during this period and the preceding years. Principles laid down in many of these cases have been also widely accepted as principles. They can, in some sense, be regarded as the general principles of laws recognized by civilized nations and, as such, might be applied as international law. What happens thereafter is also of importance not to just this paper, but also to the princely states' secession and credence to the state. In one of these cases, Dr. Babaram Saxena versus the state, they discussed the matter of the princely state of Tonk, which has signed the covenant and therefore become a part of India, but integrated into a state and a new sovereign state that was called the United State of Rajasthan. This matter came to the courts and thereafter required an extradition treaty for the survival of this integration. And in that, one of the justices noted that when a state relinquishes its life as such through incorporation or adoption or absorption by any other state, either voluntarily or as a result of consequent or annexation, the general opinion of international jurists is that the treaties of the former are automatically terminated. He goes on to also say, and I quote, the cases discussed in the connection are generally cases where independent states have ceased to such constrained or voluntary absorption by another state with attendant extinction of the former states with others. Thus, the foreseeable incorporation of, say, for instance, Hanover into the Prussian kingdom destroyed the previous treaties and extinguished the responsibilities on the state. The admission for Texas, for instance, into the United States of America by a joint resolution extinguished the treaties of independent Republic of Texas. The position is the same in Korea when it merged into Japan, and further one can refer to the writings of Oppenheim, whose opinion has been relied on by Sir Lodi. No secession, he said, of rights and duties ordinarily takes place in such cases as a political or a personal treaty that presupposes the existence of a contracting state. They are altogether extinguished. It is therefore debatable point whether secession takes place in cases of treaties relating to commerce or extradition, but here again the majority of writers are of the opinion that they do not survive merger or annexation. End quote. As far as the state of Tonk is concerned, the court noted that strictly speaking, it had not extinguished its personality entirely. Instead, several states had voluntarily united together in integrated territories so as far as to a larger composite state of which every one of the convening parties was a component. It also noted that the integration it is impossible for the state of Tonk to act in accordance with the extradition treaty, for it had lost its sovereignty rights over its territory when, as a result of the amalgamation or merger, a state loses its full and independent and absolute right of action over the subject matter of a treaty previously concluded, thus must necessarily lapse. The extradition treaty was thus declared void and inoperative. There are also further cases which discuss a similar proposition, but for the lack of time, one shall proceed forward to discuss contracts in the service of terminations upon sovereignty, as that becomes another important issue that requires further understanding. And of course, the princely states continue, and I have pasted the coat of arms of the princely state of Sarala and Cherkari, which had exercised their powers and absolute sovereignties and granted villages to the petitioners before the Supreme Court. What happens in these cases is that the covenant in the new nation was established but was abrogated by the United State of Vindhya Pradesh, which merged with the dominion of India. After the constitution had come into force, the grants had been made to the petitioners was revoked. In this view, a further matter is quoted which says, and I quote, it may be by conquest, it may be by secession following the treaty, but it may be by occupation or territory hitherto unoccupied by recognized ruler. In all cases, the same follows. Any inhabitant of the treaty can make good on the municipal courts established by the sovereign only as such as the right of the sovereign has, through his office which is recognized by law. Such right he had under the rule of predecessor avail of him nothing, nay more, even if a treaty of secession is stipulated by certain inhabitants, should they enjoy certain rights. That does not give a title to those inhabitants to enforce these stipulations in the municipal courts. The right to enforce remains only with high contracting party states. That again is an example which further cements the position and the intercourse that takes place in those formative years of the country of India. There is another matter which discusses the Geneva Conventions of 1960 and of course these are incorporated of 1949, I beg your pardon, but then they are later incorporated in India as well as domestic law, therefore emphasizing a point of dualism, which this paper shall also discuss later on. But in the said matter, which is Reverend Brother Monteiro versus the state of Goa, an important decision was laid on the law of occupation and annexation. The princely states were territories that had legal relationships with the United Kingdom of Great Britain. India were also territories that belonged to other European nations such as France and Portugal. One of those regions was Goa, for instance, which had been a Portuguese colony for the past 450 years, even till the 1960s. India annexed it shortly after. Reverend Brother Father Monteiro was a Portuguese citizen who lived in Goa. Following the annexation, he was given the option to become an Indian citizen or retain his Portuguese citizenship. He chose the latter. He received a temporary permit to remain in India. However, he continued to stay in India after the expiration of his permit. Orders were thereafter made demanding that he leaves India, which he disobeyed. He was persecuted and then sentenced for 30 days of imprisonment. Before the Supreme Court, the Reverend claimed that he was protected by the Geneva Conventions of 1949 and had been given effect by the Geneva Conventions Act of 1960. These conventions barred the deportation of certain persons during a period of occupation. The Reverend argued that the order requiring him to leave India was an order of deportation and consequently against the conventions. The court noted that the conventions not only applied in occupied territories during military occupation, because military occupation was temporary de facto situation that did not deprive the occupied powers of sovereignty or statehood. Conversely, the annexation occurred when sovereignty was transferred off the occupying power, whereby making the territory a part of its own. In the court's words, and I quote, annexation gives a de jure right to administer the territory, end quote. The court also went on to note that the Geneva Conventions ceased to apply after the 20th day of December in 1961. The Indian government offered Reverend Father nationality and citizenship, which he refused, and retained his Portuguese nationality. As a Portuguese national, he could avail only of a stay in India on taking counsel for permit. He was therefore rightly persecuted under the law applicable to him. Since no complaint is made about such a trial, the appeal must fail and shall be dismissed. End quote. But what about laws or situations that govern the relationship between international and municipal law? One should therefore be pointed to the writings of Hans Kelsen and another giant of international law, Sir Gerald Fitzmaurice, but perhaps more adapted here would be Sir Harsh Lauterpacht, because a piece of domestic legislation thus enabled international legal instruments to domestically apply and to prevail over national laws also requires reason. It is important because there is no such thing as a self-executing treaty, enabling legislation that would provide or require in every case to make provisions of international agreement operative upon persons and the cooperation of their states. And one such example is that international law automatically applied to domestic law is also municipal law. And an example of this is the European Communities Act of 1972, which permitted such an action under Section 2.1, which said, and I quote, all such rights, powers, liabilities, obligations, and restrictions from time to time created or arising by or under EU treaties, and all such remedies and procedures from time to time provided by or under the EU treaties, as in accordance with EU treaties, are without further enactment to be given a legal effect or used in the United Kingdom, shall be recognized and available in law and be enforced, allowed, and followed accordingly. End quote. To this end, Hans Carlsen noted that international law was not in its own right, and international and domestic law did not operate in distinct spheres. That is because they really are part of the same system. The unity of international and national laws is an epistemological postulate. A jurist who accepts both sets of laws as valid must try and comprehend them as a part of a harmonious system. Lauterbach argued in favor of supremacy of international law in all spheres, including domestic spheres. He distrusted the state as a protector of human rights and believed in international law to be the best moderator of human affairs. He, in one of those such instances, said, and I quote, "The hope expressed by Emerson that man shall be treated as with a sovereign state may be borrowed or brought nearer to the fruition of sovereign states, recognizing the duty to treat a man with respect and with traditional law enacted from them in relation to other states. To that vital extent, the recognition of inalienable human rights and the recognition of the individual was a subject of international law are synonymous. To that extent, the vital significance of the recognition of a higher fundamental right, not only as a part of states but also of international law, is of value. The fundamental law, as expressed and acknowledged, the ultimate reality of the independent status of the individual, constitutes both the moral limit and the justification of the international legal order. Through them, it implies a promise that organized international security and society will not in turn degenerate into tyrannical accumulation of power. But what about India, and what about the status quo in our country? Well, one such instance, Justice Krishna Iyer noted that, and I quote him here, "Until the municipal law is changed to accommodate the covenant, what binds the court is the former, not the latter." He also points out that international conventional law must go through the process of transformation into municipal law before the international law can become a part of the domestic system. He also noted that the remedy of provisions such as these, and also the breaches of international law, is not to be found in the courts of laws of the states, because international law per se, or provisio vigore, has not the force of authority till it becomes civil law. Under its inspirational impact, actual legislation is undertaken. End quote. This also demands one to consider the doctrines of transformation and incorporation. However, given the shortage of time, one should proceed swiftly towards cases perhaps such as those of the Visakha guidelines, wherein the guidelines of sexual harassment were brought into case, and perhaps today being an ominous day, having just celebrated International Women's Day just yesterday. Another case that is of importance and relevance here is the gramophone companies versus India versus Birendra Bahadur Pandey, which discuss the Committee of Nations that require the rules of international law to be accommodated into municipal law even without express legislation sanction. They do not provide in a run-in with the Act of Parliament. Therefore, while the decisions in these courts support the doctrine of transformation, which has not been overruled, the Supreme Court seems to have moved in the direction of the doctrine of incorporation. Most recently, the court found the acceptance in the decisions of Nalsa, where the court supported and upheld the rights of transgenders, and also in the case of Puttaswamy, where the court found that there was the right of privacy under the Indian Constitution. It must also be stressed, however, that while the supporting of the doctrine of incorporation, the Supreme Court does not say that international law is directly effective or enforceable in India. In reality, therefore, courts only use international law as an aid to interpret domestic law, at times to fill the gaps and at times to find implied meaning. In Nalsa and in Puttaswamy, for instance, they use international conventions to interpret fundamental rights of the Indian Constitution. As such, it is the domestic law that continues to apply, just as it did under the doctrine of transformation. But what about the proof of international law? What you see on your screens, dear friends, is Lord Mansfield, who in his decision in 1774 in Moinstein versus Fabregas noted that while considered as a contempt, say for instance, and he speaks about the French system here, that it is not applicable in England, English lawyers are competent to not argue French laws, thereby questioning the regards to which the foreign nations say no are in effect question of fact that must be proved through evidence. Indian courts similarly noted that the Evidence Act is the only act which is responsible and also valuable in judicial notice of all acts of British Parliament. The laws of other nations must be proved. In practice, however, the Indian courts tend to be more flexible and often take judicial notice of legislation and court rulings of other nations within their meaning. Borrowing from civil law traditions where the process is adversarial, judges may also undertake their own research to determine what a nation's domestic law says on another issue. And in construing international law, the Supreme Court, say for instance again in the Nalsa matter, noted that the Articles 31 and 32 of the Vienna Convention on Law of Treaties must interpret the treaties in good faith and in light of the object and purpose in which they were envisaged, thereby underscoring the point made by Judge Jessup in the South Africa and Western case, wherein he noted, at least in terms of dissent, as the intelligence of the future day. But what about our system? What about the Indian system? Courts in the modern democracies as the one we live in also maintain relations not only with itself but also diplomatic relations between two nations, which might from time to time deteriorate, which further enhances political discourse between them that might be, for instance, be unpleasant. Courts, for instance, in Pakistan, despite the country's strained relationships, rely on the Indian judgments heavily, showcasing a laudable defense. Independent judicial branches have preferred to progress on their own terms, unmoved by politics that surround them. Thus, even if national governments adopt a politics of seclusion, municipal courts can be trusted to ensure that the majesty of international law is not just undermined. Precisely because their authority is not subject to public opinion, judges must have the freedom to incorporate foreign and international law, even if the leaders in their nations reject these ideals. This gives one reason to look at international law and the international legal order optimistically. As long as the international agreements exist among nations, courts will engage with them, unaffected by uncertainty, might engulf the international legal arena. With those words, I thank the organizers once again for giving one a chance to share his thoughts and perspectives, although being short and precise is something which, at least in this instance, has been a virtue. Thank you.